Good evening. That it was too long before victims' voices were heard, and we're grateful for the laws in the state of Florida and for the attention that you give our victims, and hope that it was too long before victims' voices were heard, and we're grateful for the laws in the state of Florida and for the attention that you give our victims, and hope you will do that in every case. I'm very proud of our office. I'm especially proud of John Guy and Aaron Wolfson for the excellent job they did in this case. Their opening statement and closing arguments were really, really good, to tell you that. And we will never shrink from that duty. is dedicated to seeking justice for our victims. I've told you that before. I will continue to tell you that. And we will never shrink from that duty. I'm very proud to work with John Rutherford and his detectives. They did an excellent job in this case. And all of you were here and you heard the evidence, which we can't discuss much because of your questions. But we are very, very grateful for the working relationship of a pending count that will go to trial again. Then we will try to answer some of your questions. But we are very, very grateful for the working relationship with the Jacksonville Sheriff's Office. Last year alone, we tried 39 murder cases with them here in Duval County and in Clay and Nassau in our circuit. And those cases are all equally important. Ron and Lucy are representative of the type of victims who have to deal with this every single day. And if you don't know, tomorrow would have been Jordan's 19th birthday. And they will spend that, I'm sure, wondering a little bit about this verdict, but as they told you, grateful for the justice that was served and the justice that is yet to be served. I'm happy to take questions at this point, and Aaron and John may answer some of them, but what is, Leslie?
The fact that you have to retry this one charge, your reaction to that?
Well, we have to retry cases. We had a whole slew of cases, Leslie, you might have been familiar, when the Supreme Court changed the manslaughter instruction. We had to retry several homicide cases. And so we just get ready and we come back into court and we work just as hard and we seek justice in the same way. So retrying a case is something that we've all had to do and we will continue to have to do, and we'll give it the same full attention. We don't back off having to retry. Yes?
Forgive me for not knowing, is it possible to come back with not a first-degree charge, but a second-degree charge and retry?
We could make that decision, but at this point, if we retry Michael Dunn, it will be for first-degree murder. So right now, that's the grand jury indictment, and we would proceed, as the judge said, he mistried that count only, so we would go back to trial on that count alone.
Was it a mistake to do first-degree murder? I mean, they dropped it to second and mistried. Would it have been better if you'd done second-degree from the start?
Absolutely not. And I know that you all have brought up the word overcharge before. I think it came up yesterday. I know it came up in the months after the Zimmerman case. Let me just say this, and hopefully this will help you understand. The state of Florida has a lot of good laws on the books. One of the best laws and one of the best rules of procedure is called a motion to dismiss. And if any criminal defense attorney thinks that the state of Florida in any particular case has filed charges that shouldn't have been filed or has filed an overcharge, they're welcome to file a motion to dismiss pursuant to this rule. And it happens a lot in cases, defense attorneys do, but they have to sign their name to it. It has to be a sworn motion. It's called a C4 motion under Rule 3.190. And it's a normal practice in the state of Florida, so I'm not really sure why any criminal defense attorney would ever complain and chronically complain about overcharge when they have that tool available. What's also available through the legislature is a stand your ground motion, which was not filed in the Zimmerman case. It was not filed in this case. And so that would be another way to dismiss charges that they believe should not have been brought at all, or charges they believe are an overcharge. And the third thing, Mr. Hammond, that you're probably familiar with is the motion for judgment of acquittal. That's one more way a defense attorney can attack the state's case claiming an overcharge. And there were 3 motions for judgment of acquittal in this case, and the state prevailed on all 3. One more thing you might want to know about is the jury instruction that tells the jury, if you don't believe that the state has proven the highest crime charge, then you're to consider the lesser includeds. Now, 10 times out of 10, when someone fires 10 shots into a car full of unarmed teenagers, we will file first-degree murder and attempted first-degree murder. Premeditation doesn't require any specific length of time, and that's the aspect of it on which we rely to file these charges.
What's the sentencing guideline for what we can get with charges he's been convicted of today? What's the minimum, what's the maximum?
I was going to let Ms. Wolfson address that. Aaron Wolfson?
As to the 3 attempted second-degree murder charges that he was found guilty of, he's looking at 30 years for each count. And within that 30 years, then, there's a 20-year minimum mandatory for each count. And then count 5, which was the shooting or throwing deadly missiles, is 15 years.
Yes, ma'am.
So if he's already looking at a minimum of, let's say, 60 years in prison, what would be the point of wasting or using government resources to retry him on the first charge?
Well, I certainly hope wasting was a slip of the tongue, because justice for Jordan Davis is as important as it is for any of our other victims. The other thing is, as you all know, the defense has a right to appeal this case. And sometimes just a mere slip of the tongue from a lawyer, from the judge. One of the things we've had a lot of problems with are the jury instructions. They're about to change the justifiable use of deadly force instructions on us again. They also just changed the manslaughter instruction in the middle of this trial. So any one of those things could cause a retrial on the 4 counts on which we got a guilty verdict. So we would always try a second case or an additional count to make sure that if something happens on these other charges, we have that in place as well. So it's an excellent use of state resources to make sure that someone does not get out. Yes, sir.
Are you expecting that the retrial will happen here in Duval County?
Yes, we are. And we intend to fully push for a trial right here in Jacksonville, Duval County, Florida. Yes, Kevin.
There's been some questions, some people criticized that you didn't spend enough time describing what kind of a person Jordan Davis was, and then let the defense sit there and say things like, well, he was fearful of him, and not enough time saying that there was really no reason for him to be fearful of him.
A lot of times we can't put on good character evidence of the victim, and it becomes ripe for reversible error. We put on as much as we could by eyewitness testimony and physical evidence that proved that Jordan Davis never got out of that car. So again, because that count is pending, I can't go too deeply into it, but we put on everything we possibly can within the bounds of reason. And there are times, Kevin, when we have to make a conscious choice not to risk, reversal on appeal, but we walk a delicate line with that, and sometimes we do our best, and we think we've done it the right way, and the appellate court says no, but we still go with what we have. This was a case full of eyewitnesses and physical evidence, so we didn't believe that was that much of an issue.
Is it definite that you're retrying? Is there any doubt that you're going to try him again for the murder charge?
Well, we have to sit down with our victim's family. Obviously, we hope to do that in the next couple of weeks, but as far as we're concerned right now, we intend to retry Michael Dunn on first-degree murder.
Are you surprised it took this long for the jury to reach a decision or a not decision?
The interesting thing about jury verdicts is we've tried 3-week-long cases where the evidence itself took 3 full weeks long and gotten 45-minute guilty verdicts. I can remember trying a case in Nassau County, a first-degree murder case with a 9-minute guilty verdict. Sometimes they're long and sometimes they're not. This jury had a lot of work to do, and we thank them for their careful attention to everything in this trial. So I can't say we're surprised, but, we're not back there. We don't know what's going on until the verdict finally comes out.
Do you have any thoughts on why they hung, and do you see yourself making any changes in the second trial to make sure you don't get acquitted?
Well, we always make changes. The first thing we do, even after a guilty verdict, is say, how could we have done it better? And we always learn for the next time. So I anticipate that there could be some changes. Yes, sir. Yes, ma'am.
I was going to ask something very similar. So what lessons would you take from this verdict, and what would you present to the next one?
Oh, we take all sorts of lessons from every verdict. And even when it's guilty as charged, we take lessons from those. How to present a witness more smoothly. What else could we have put in? Things like that. How can we do it better next time? The jury instructions are very burdensome, so we'll be devoting a lot of time to looking back over the justifiable use of deadly force instructions. That's probably one area. We spent a lot of time. I don't know if you all were aware of it, but we probably spent in excess of 8 hours working on justifiable use of deadly force alone, behind the scenes and in the courtroom, trying to make sure we were doing it exactly the right way. I think someone said, and I can't remember who or where, said this was an easy case for the state attorney to come in and try. No case is easy. There are nuances to every case, and their jury instructions are always complicated, and they are especially so in justifiable use of deadly force cases. So we've learned a lot, and I think we'll go through with that. Now, as far as count 1, until we know why they were a hung jury, they did not acquit, so until we know why they were a hung jury, we wouldn't know what to adjust. And juror feedback is excellent for that. And if we get the juror feedback, you all heard the judge say the jurors are at liberty to speak with whomever they please. So we hope to hear from them on what we could do better. Yes, sir.
Forgive me for not knowing, but what is that feedback process like? What do you hope to hear from them, and do they have to talk to you?
No, they don't. They're allowed to talk, and we frequently have had cases where a juror will call the office and say, I'd like to tell you what we talked about back there.
And so they'll come to you and say, this is what I think you did wrong.
Well,
Or this is what we think that didn't work. This is why it wasn't convinced.
they could say that, but obviously they were out for a long time, so some of them were convinced, is what we're assuming, based on past experience. But we'll just wait to see. But, until we hear from them, we won't know.
The sheriff's office?
You have to wait for them to contact.
Yes, we are not allowed to contact jurors in any case. Even if there was a fully guilty verdict, we're not allowed to contact jurors at all, and neither are you, by the way. They are allowed to contact who they wish, and they're allowed to speak to who they wish. As the judge said, they're at liberty not to speak with anyone ever about their deliberations. They're at liberty to speak with whomever they please. Yes.
Overall, how do you feel about the outcome of this case?
Well, when you're seeking justice for 4 different victims, and you get a verdict that speaks to justice for 3 of those victims, it makes you more determined to seek justice again for that 4th victim. So that's how we feel, and we're gratified at the jury's findings, and we just intend to go in and fight hard again for Jordan. And we haven't had a chance to talk to Tevin or Leland or Tommy, but we intend to do that either this evening or tomorrow or Monday.
Did the sheriff's office make a mistake not searching that parking lot earlier? Even after Dunn spoke, there was still a 2 to 3 day break before that parking lot was searched.
I think that would probably be going into too much of the details of the case. I will say once again, we have an excellent sheriff's office, and these homicide detectives do an excellent job. There were eyewitnesses in that parking lot, as you all heard. You did hear the evidence as it came out, and you all were very attentive, I know, and followed everything in court. And so I can't imagine how there could be fault at all based on putting everything together. You know, when you put one circumstance together with another circumstance, eyewitness testimony together with a lack of physical evidence, I'm not quite sure how anybody could blame them for that. So.
Part of the difficulty here that Mr. Dunn, there didn't need to be a gun, he just needed to be convinced that he saw one.
Our jury instructions are very difficult, and they do read in the manner that you just suggested, that the person in that position doesn't have to see something actually, but the fear it still has to be a reasonable person standard. So that was an excellent point that you just brought out about Florida's justifiable use of deadly force.
Ms. Cory,
yes, sir.
The Coalition of African American Pastors who was here for the last 2 weeks asked me to convey thank you on behalf of those young men, African American young men. They asked me to stay and publicly say to you thank you for working hard for them as victims, and they appreciate, and they're going to contact them later.
Thank you, Pastor. Thank you.
Cory Strolling yesterday mentioned politics as being kind of the background in this case for you as a candidate in the future, and perhaps there are political implications.
In this case?
Attached to winning or losing. And I just wanted to get you to comment a little bit on that.
Yeah, I'm happy to comment on that. There's nothing political about what we do. We file our cases based on the facts and the law. I'm not sure where he got the word political from, because I have been on this case from the very beginning. I talked to Erin. Where's my Erin? There she is. This was Erin's first call out on a homicide. She had just joined our homicide team, and this was her very first call out. And I talked to her very early on and said, Erin, I want to do this case with you, and I want to teach you how to do discovery my way. Not to pick on John Guy's discovery, but I have a very specific way I do discovery in homicide cases. So I did the discovery in this case. I actually did that work with Erin. We worked side by side. That's the part of a trial I love. I'm a board-certified trial lawyer, and I got that way from trying homicides. So it's not political for me. This is what I've done my entire career. And what you don't see that we do is the nuts and bolts work behind the scene. The discovery is burdensome. You've seen the discovery response. That's my spreadsheet that I typed every word into. The other things that we do behind the scenes that you don't see are things like getting the evidence ready to go, the jury instructions that I typed myself and edited are very burdensome. So those are the parts of the trial that I love to do. I'm not quite sure how that's political, quite frankly. And I also did Mr. Stroll's PowerPoint for him, so I'm not sure why he thinks I'm in this for anything other than the love of trying cases on behalf of our victims. So I can't answer to his allegation about that.
Did the George Zimmerman trial verdict have anything to do with your decision to pursue this case?
How could it when we indicted Mr. Dunn last December? And the Zimmerman verdict came out 8 months after that. So I was on this case actively working it with Aaron Wolfson 8 months, I think, before the Zimmerman verdict. So
You decided to try this case yourself.
well, I decided back then to try it myself. When I started working with her on it then, at that time, how would we know this was going to become such a huge media event?
Why did you decide not to take a larger role in the questioning of witnesses and opening and closing when you had said you were going to try it?
Are there any other questions?
Why didn't you seek the death penalty?
Well, that's one of the things that we weigh in aggravation. There are certain aggravating and mitigating factors under Florida statutes, and you weigh those aggravating and mitigating factors, and if they're not present by law, we don't seek the death penalty. So we went through that process, and that's why we decided to seek first degree but not seek the death penalty.
Thank you.
Thank you so much.
I've received all of your requests.
We've been listening to State Attorney Angela Cory, who has already made clear tonight she plans to retry